whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause, a podcast originating in Allen County, Indiana, and centered on legal and court proceedings and news in all of northeastern Indiana. I'm your host, Jamie Duffy, a local journalist. To my left is Michael McAlexander. He is the Allen County Prosecutor. He's fabulous for his invaluable insight. Also contributing is my right hand, who wishes to remain anonymous at this point, and we're glad to have her, and so we have no problem with that. She has helped many people navigate the legal system here and has experienced it from the heartbreak of homicide when her son was killed in December 2016. Today, we're going to be discussing mistrials. You do hear the word mistrial often. Maybe you're not exactly sure what it is. So we're going to discuss that. We have Mike here to go into all the details, and so we're very lucky that way. But I think first we should go to the weekly court news. Mike, what's going on this week in Allen County?
Well, we had a lot of trials set, but
we did.
We had a speedy trial that was ahead of two homicide cases, or an attempted murder and a homicide. And on that one, they so it went, or started to go, and then the defendant at the last minute pled what we call straight up without benefit of a plea agreement. So a trial didn't go in that court. And
so wait a minute, hold on a second. He pled straight up without the benefit of a plea deal. So do you craft a plea deal afterward?
No. It's the same situation as if somebody goes to trial. The way it works, if you can go in and plead, as I said, straight up without benefit of a plea agreement, the probation department, if the court accepts the plea and determines it's knowing and voluntary, they will then forward the case to the probation department to create a pre-sentence investigation. Then they will go ahead and sentence pursuant to Indiana law according to the factors, mitigators, and aggravators that may apply to the defendant.
So was this for a homicide?
No.
Okay.
This was possession of a gun, I believe.
Oh, yes. A machine gun, I believe.
I'm not sure.
Okay, so I will check that one out.
But the point is that the case is behind it, and there was a murder case and an attempted murder case, along with, I think, at least a couple of other cases. All were congested on court congestion because they locked the one case in. So we didn't have that case go. In another court, we have a child molesting case going. So we have that. And that also bumped a homicide case. It was a speedy trial as well.
I know, I was getting ready for them. So
as we said before, speedy trials take precedence over other settings.
Right. So I might look onto that because, you know, I have been writing for the website and our podcast page.
Actually, it's not a child molesting. I think it's a neglect of a dependent case that's going this week.
Yes, I know that name. So I wanted to add that our homicide unit, that depends on other units like vice and narcotics, like the gang unit, like the detectives on the street, they are right now 8 on 8. In other words, there have been 8 homicides. They have made 8 arrests. That gives them a 100% clearance rate, not conviction rate, because people get that confused, but a clearance rate, and that is amazing. So kudos to the FWPD for that. It's highly, I don't think anybody else in the nation is doing that right now. And
It's hard to get better than 100%.
it is very difficult to beat 100%.
No, I've not heard of any department of any size having that kind of a clearance rate. I know Marion County's clearance rate is much, much lower.
Like 50?
And I'm not even sure if they're up to 50. And for years, we were in the 50 to 60% rate. And I think I threw this stat out last time that we averaged in the 10 years from 2010 to 29 through 2019, we averaged filing 10 homicides a year. From 2020 through 2024, 5-year period, we have averaged filing 32 homicide cases a year. Now, some of those might have multiple defendants on the same case, so it's not a direct correlation to the number of homicides, but it is definitely a significant number and shows the great work that has been done by local police agencies.
I know, we're going to have to see how many are in the jail again. They are filling up our jail, the people who are waiting to go to court on a murder charge. So let's get my right hand on the phone now, please. So on to the subject of mistrials. This is what I got from AI, and I know that Mike's going to fill us in, and also my right hand, who has personal experience with a mistrial. So number 1 is hung jury. The jury is unable to reach a verdict after repeated attempts. Maybe not just one, but repeated. Number 2 is serious procedural error or misconduct, improper admission of evidence, misconduct by the court, counsel, parties, or witnesses, or jury errors. Number 3 is death or incapacitation of a juror or attorney. Number 4 is discovery that jurors discuss the case contrary to court instructions, and when you are in our courts, you will hear the judges tell them what they can discuss, where they can discuss, only after the trial, etc. Number 5 is juror misconduct. We do have a very famous trial that will be coming, that is going to be starting on April 1st in Massachusetts. A lot of people are following this in the U.S. Her name is Karen Reed. Her second trial starts April 1st. After last April, she had a mistrial. She's been charged with murder in the second degree, which we don't ever hear about here. She is accused of striking her now deceased boyfriend, whose name was John O'Keefe, with her SUV in January 22 in a little town outside Boston. Just think, it was really cold, it was snowy, it was dark because they'd been partying all night at a bar. Then they decided to go to another Boston cop's house. So while they were there, she left. The prosecution says that she backed into him and she left him for dead. He died of, bleeding in his brain, swelling, and also hypothermia. The defense is saying that there was something fishy that happened in that house. They think that maybe he got beat up and then kind of kicked to the curb, and that's why he died. So we might follow that just for the interest that it's created, because I'm telling you, there are a legion of supporters. Every time she walks out of that courtroom, everybody's got signs for her. I would say mostly women are really her supporters, but it's blown up into a national case. So with that, let's go on to Mike. Mike, do you have any kind of trials? I mean, you just said there was one, I think, last week, a mistrial.
Well, the most common mistrial is a hung jury. And this is where a jury goes in to deliberate and they're unable to get a unanimous verdict. Indiana and most jurisdictions require that all the jurors agree on the verdict. So you need to have all 12 jurors move in the same direction. If they move in the same direction for not guilty, you get a not guilty. If they all move together to find the person guilty, you get a conviction.
Exactly.
So, so technically, when that happens, and usually the court it used to be more common. They called it an Allen charge to kind of tell the jury that they've heard all the evidence. It's not going to get any better. They need to make a decision. The appellate courts have shied away from that kind of directive to juries.
Did you call that an Allen?
Yeah, it was named after a case.
Oh, okay.
But usually there's some indication that the jury will let the court know that, hey, we're deadlocked right now, or we don't think we can come to an agreement. They'll send a note out, and depending on what that is, it'll vary on how the court either answers them or just says, please keep on working.
Right, so they'll send them back, see if you can
find agreement, see if you can come to something, and do it that way. So that's the most common form of a mistrial hung jury. And that really gets into some stuff for certainly the prosecution, because we have a choice after that as to what we want to do with the case. We have the right to be able to retry the case. We can also look at it and say, well, maybe this case isn't winnable. And some of that, I know I usually want to know, the first thing is, what was the split? If it was 11-1, you might just have one person that, for whatever reason, either wasn't paying attention the way the others were, had a different view, have something going on that they are just not going to move and be convinced of anything. On the flip side of that, if a state's case is 11-1 for not guilty, I take that as a message that we need to look at our case and say, well, maybe we've overreached for this fact situation. Or is there something that we didn't do that we should take a look at? And is there something we can add in a subsequent trial that would help us get over
Are you
whatever the
allowed
problem?
to speak with the jurors after this?
It varies depending on the judge and the jury. There is no mandate that a jury hang around with to talk. My experience has been actually with a hung jury, they're kind of more interested in continuing to talk because they didn't come to a conclusion. They're still trying to convince people of what's going on. So, and sometimes it depends on the circumstances. If you've got a jury that's been deliberating for 10 or 12 hours, or it's 2 o'clock in the morning, they want to go home. So they may not be inclined. But we've also had situations where jurors will contact us after the trial is over and want to talk. Part of that is it can be very emotionally trying for jurors to go through this process. And I think, in a sense, the worse the case in terms of how the victim presents can be very disturbing for jurors. And you've covered enough trials. You've seen jurors come out of this very emotional. So,
well, I've never actually talked to a juror because I'm afraid you guys would kick me out.
Well, they're not going to let you do it in the courtroom.
No,
usually.
I would never. I know the rules, okay? And actually, to be honest with you, a juror has never contacted me. Go ahead, right hand.
I was just going to say, isn't it like completely up to the jurors whether they talk or not? Like the judge can't order them to talk and you guys can't make them. It's completely up to them.
Yes, very much so. So sometimes you'll get a handful of them that want to talk and the other ones leave. I've seen the behavior where they want to stick around. Other times they all just want to get away. And then some of them may or may not come back and reach out. Or if they have friends or family. I think we had one recently where one of my deputies said his barber was on a jury and wanted to talk to the deputy who prosecuted the case. So that kind of thing happens enough that it's not unusual.
That's interesting. I've got to tell you an anecdote here. I'm sorry to break this up, but last year when I was in France, in a little town called Alençon, there was an attempted murder trial. And of course, he did it. He deserved the 10 ans ferme that she gave him, which is 10 years closed, no chance to get out, right? But the judge, and they have 3 judges in the panel, not just one,
Okay.
told the jury at like 1:30 in the afternoon to come back at 5:30 with a verdict. And they did. And I couldn't believe it. And then I talked to the reporter who was covering it, and he said, yeah, that's what they usually do.
Well, that wouldn't fly here.
No, it wasn't. And they are a democracy too. I just want you to,
Well, and there's different ways of determining that. We put a lot of faith into our jury system.
Yes.
And I think the quote is something along the lines, it's a flawed system at times. Certainly judges and prosecutors and defense lawyers sometimes will think, were we in the same room for the last 3 days with the 12 people that were sitting there? But it's also the best system that we know of. So it is.
I always try and read the jury. I'll watch them come in and, oh, she looks like a, pointing her finger type, and this guy looks like a hipster. I'm just like trying to suss out, but you can just never guess how they're going to go.
I think that's true for most lawyers there's a lot of studies about how to pick a jury and the theory of group dynamics. And one of the current ones is you want 1 or 2 leaders and then more followers. You don't want too many independent thinkers. There's a lot of...
God forbid we have independent thinkers. Okay, go ahead.
Well, you don't want people that are speculating.
Right.
As opposed to, they're instructed to listen to the evidence, make their decision based on the evidence, not based on sympathy or bias for or against a victim or a defendant.
Do they ever ask him, like, how many crime shows do you watch?
I think depending on the case, yeah, their TV viewing habits are something. We have run into this whole issue with juries in the last 20 years or so that's called the CSI effect, where juries expect to see scientific evidence on every case. And when it was just 40 years ago, when it was just fingerprints, you could sometimes explain to them that no, not everything you do leaves a fingerprint. But now...
And not very often, honestly.
And now even if we don't have evidence that way, we frequently call a witness to explain why there was no DNA in this case or why there were no prints.
Well, I would say you often get more DNA than you do fingerprints.
Oh, yeah, I would say so.
Yeah, fingerprints are so elusive, it depends on the surface.
But that whole mindset from some of the TV shows has changed what jurors have come to expect. I would say the same thing now about a single eyewitness to a crime, or use your gas station holdup kind of thing, where studies have been done on cross-racial identification being somewhat suspect, eyewitness identification in general not being as reliable as other evidence. And so jurors are looking for something. The worst thing you hate to hear from a jury is, well, we believed the victim, and this is frequently in sex cases.
Oh, okay.
We believed the victim, but we just needed more evidence. And that's part of the reality that we have to recognize when we bring a case, that you've got to have some corroboration these days. We have, I think, people that are not necessarily skeptical, but let's face it, the news media publicizes whenever there's somebody who's on death row who is allegedly exonerated or gets a new trial. And we have to be very careful of the record, what we call keeping the record in good shape, to make sure that we've provided enough evidence both for the appeal, but the jury in its own way is wanting to make sure, they don't want to leave that courtroom saying maybe.
Right.
What if he didn't do it, kind of thing. They want to feel comfortable that they did it. In past days, I know there was a period where we used to bring juries in. Now when we would bring a jury in, they're in for just that day. We used to bring them in by quarters. So like January through March, you'd have the same panel, maybe come in 2 or 3 or 4 times. And in those days when we probably had more media coverage, we might get a hung jury or something on a burglary case. And then your former employer would write up a story.
Now, which
saying,
one? Are we talking about the Journal-Gazette?
Well, when I said write up the story, you
Okay.
can pick your own.
The print media. All right.
But they would frequently put in the stories that the person had been convicted of or was on probation for something else. They'd put in a little bit of their criminal history.
Well.
So you'd have a more, if you will, either you could call it sophisticated or tainted jury by the end of the quarter that was less likely to believe.
Oh, so in other words, they were reading these when they were out and not serving on a jury.
Right.
Oh, that's not a good idea.
Well, and that's part of the reason why we don't do the quarterly jury call anymore. So there's a lot of things, getting back to mistrials, that can go wrong with a jury. Over the years, we've had mistrials due to, now I think we're doing a lot more where we're serving the jurors lunch, but so often...
They used to have to bring their own brown bag, did they?
Well, usually they didn't know what was going to go on, whether they were going to be picked or not. They come in. Usually we're able to pick a jury in the morning, and then go to lunch, come back at 1:30, and you might have all sorts of weird things happen, that they go to a local lunch spot and a family member of the victim or the defendant or somebody talks to them. That has created problems. That's why we usually put alternates on the jury now to avoid those kind of problems.
So that would be like number 4, discovery that jurors discussed or heard about the case contrary to court instructions. Okay.
When we send jurors home overnight, they're instructed not to watch, not to discuss it with anyone, but also not to watch any news accounts that may happen.
Right.
Well, what if they did? Or they happen to say, hey, I saw this on the news last night. And suddenly you've got not just one juror tainted, but 2 or 3 or more.
Oh.
So you've had juror misconduct, you've had witness misconduct that approach a juror. We have rules about
Wait a minute, witness misconduct? Where they actually approach a juror?
Well, witnesses are instructed to not discuss their testimony.
Right.
And sometimes they share what they did with other witnesses.
So I see the jury walk out quite often. And so somebody would have to waylay them to do that.
Yeah, it's usually not in the courthouse kind of thing, but they might ride on an elevator together. You've been in courthouse. Our elevators are not exactly large.
Oh, they're very cozy, actually. And they work. So I like that
So all
part.
sorts of communication violations can occur during a trial that could result in a mistrial.
Have you had too many where there was the death or incapacitation of a juror or attorney?
We've certainly had situations where a lawyer or on either side or a judge gets sick. When we had COVID, when people were taking 2 weeks off if they tested dirty or tested positive for COVID, we had to suspend things that way. We've had issues periodically of not having enough jurors called in to pick a jury. The case we have going this week, it took them till I think 3 o'clock yesterday afternoon to pick a jury.
Oh, that is long.
They had a lot of people that had trouble with the type of case it was. And
Can you say what type that was?
I just as soon as not, but
those are hard.
But it's still, when you get into issues like that, when the jury kind of knows what the case is about, a lot of people just simply say, I don't know that I could be fair in that kind of a situation, either because of something that happened in their lives or to a friend or family. And a lot of people have an aversion to child molesting cases or child abuse cases.
I just don't think you can be accused of anything worse almost.
I think generally that's probably the biggest area for our jurors to struggle with, to say, I don't want to hear that kind of a case.
Right. It's too disturbing. You can't go to sleep at night. I used to read the probable cause on those early in the day so that I wouldn't think about it when I went to sleep, because it was very difficult to go to sleep with some of them. I mean, horrible.
And along those, back to kind of the COVID with jurors, we used to have, I think it was in the 85% appearance rate of people that were summoned in for jury duty would appear. When we hit COVID, that dropped to about 50%. And it took longer to pick a jury, it took longer to try cases because everybody was spread out. We couldn't bring as many people in at a time to pick the jury. So we ran out of jurors sometimes. So
Yeah,
that
you
can
were saying
create
that.
a mistrial. There are so many things
That's
that
got
can
to
go
be so
wrong.
disappointing when you all get in there, you've got your evidence, you've got your witnesses. That, I can't get a
Now,
jury.
this wasn't technically a mistrial, but I had a case once that was going to be a 2-week trial that we tried down in central Indiana. And we got there that morning. We had a hung jury like in June before, and now we were like in the second week of January for the second trial on this case, and walked into the courtroom that Monday, or actually into a side room that Monday morning, and the defense counsel was sitting at a table in absolute misery. He was having kidney stones.
Oh,
And so we were set for the 2 weeks, so we thought, well, we can kind of hold off. So we sent the jury home. We waited a day. We waited a second day. He still hadn't passed them. Then we decided that we couldn't just keep them on hold for that long, so we canceled the trial at that point. Technically, you don't get a mistrial till the jury is sworn in.
so was that called a mistrial?
It wasn't. It was a resetting.
Oh, a resetting.
But that could have happened on the third day of trial. It could have happened after the first week of trial if we'd come in and he had that issue and wasn't able to go forward.
You can't just call in and say, hey, I'm going to the hospital.
You know, over the years, there are so many different ways that cases can get messed up. Outbursts in the courtroom.
Oh, yes. Although that doesn't always result in a mistrial, right?
Not always. The rule is a defendant can't cause his own mistrial. On the other hand, if it's something that taints the jury on a practical basis, you're probably stuck with the mistrial.
I mean, I think the judges here really know how to handle the cases. And I have been to other counties, but probably not, well, no, Kosciuszko County, but there were no outbursts there.
The other thing that frequently happens on mistrials is in the midst of testimony, a witness says something that they shouldn't say. Generally, we don't refer to the defendant being in custody or being arrested before or being guilty of past crimes unless he takes the witness stand. So we avoid terms like rap sheet or mugshot. And
That's not really funny, sorry.
But periodically a witness says something that they shouldn't say. And depending on the severity, usually the court will try to fix that with an instruction to the jury to disregard that testimony. But sometimes if the court feels that it's gone too far and will eliminate the ability to provide a fair trial, they will go ahead and grant a mistrial.
And that's what America's all about, in my opinion.
And there's recent cases that the state, if they ask for a mistrial, which usually doesn't happen, but if we ask for one and the appellate court decides that it wasn't warranted, it's treated the same as double jeopardy, and we can't retry them.
So you're very careful.
We have to be very careful.
Very careful. I think it's time to turn over to my right hand here. Can you tell us what you went through? Because you went through a mistrial and then another trial. If you want to talk about that.
Yeah, actually, I have a question for Mike first before
Okay.
I forget. Is there a limit on the number of mistrials they can have in a case?
No. I mean, it's
I'm familiar with a case that had a mistrial because I forget the first reason, but then the next reason was a hung jury, and then the next time they ended up having like 3 mistrials. Only one of them was hung jury. I think the defendant misbehaved in court, and that caused a mistrial. I don't remember all of them, but anyway.
Was that in
they-
Allen County?
Yeah, there were 3 mistrials in that case, but then you finally ended up getting a conviction. But in my case, we had a hung jury the first trial, and going through the first trial, all of that was new, and I didn't even understand really what a hung jury. I mean, I understood what the words meant, but just how it took me a minute to figure out how it affected our case. And then I wasn't sure, like, can we try it again? Like that question comes up in every family's mind who has a mistrial or a hung jury, because they don't really understand what that means. So for me, like, I was very much put at ease when I was finally able to talk to Tom and get or talk to our prosecutor and get clarification that yes, they were going to try it again.
And she's talking about Tom Shaley, who is the
chief deputy.
I always want to say chief deputy in the Allen County Prosecutor's Office.
Yes. Yeah, you can retry a case. I had a special prosecutor case from another county that we tried 3 different times. Each trial was 2 weeks. We had a hung jury the first time on a roughly a 9-3 or 10-2. And then a second trial where we got a conviction that was later overturned on appeal, which I don't like to talk about.
Okay.
So
Can't imagine why.
And then we did a third trial, and we got a 6-6 split. And on each of those trials, we had 4 alternates, and we pretty much knew where they were. And so out of that 48 jurors, when you took all 3 trials and put all the juries together, it ended up being like 36 jurors voting for guilty and 12 voting not guilty.
So too bad it doesn't count.
Right. But
it's like you keep score in the prosecutor's office. I love it.
And on that one, we ultimately determined that it may just be one of those cases that we would be very hard pressed to ever get 12 people to agree.
Okay, was it a murder trial?
Yeah, it was a triple murder.
Oh, wow.
So, and as a matter of fact, it's a case that had a lot of notoriety in the South Bend area. And still we get calls periodically about it.
Interesting. So, my right hand, what can you share about your case? Because you ultimately did get a conviction the second time.
Yeah, so after we got the mistrial, I overthink everything, and so I thought about and went through them in my mind's eye, the whole trial, and where things didn't get tied up real nice and neat in a bow, tying everything together, and just some things that I felt like the prosecutors missed or didn't discuss fully enough, or things like that. And I actually found a juror who gave me a lot of information. I think she gave me like 6 pages of notes of where the jury was misled, or not necessarily misled, but where the jury didn't take the evidence for what it was supposed to represent.
There was some confusion with it, right?
Yes.
That fair to say?
That this juror relayed to me that there was a lot of confusion in certain aspects of the way that the prosecutor's version of events and the defendant's version of events didn't match up. And so they clearly were having an issue trying to rectify whether it was the state's case that was the truth or the defendant. So I actually then met with the prosecutors that were on my case and went over. I had like 9 pages of notes, 6 of them coming from the jury and 3 of them coming from me and my family. And so me and my parents went and met with them, and they were so accommodating, and it was really refreshing that to see that they like sat down with us and went through every talking point and explained their position or why they didn't. Or I mean, there were a few things that they were like, oh, that's a good idea. You know what I mean? Like, so there were things that they hadn't thought of that we did think of. And fortunately, we were given that chance to have a second chance at trial and not getting the not guilty verdict. So anyway, so the second trial, they did tie up some of those issues that we had found from the first trial. They put together a very nice PowerPoint that kind of walked them through the timeline more clearly visually, and we got a conviction fairly quickly. I mean, our first jury was out from like 3 p.m. until 12 o'clock at midnight, like between 11 and midnight. And we were at the courthouse the whole time because at that time they like to trap you in the courthouse. And if you left for any reason, you couldn't get back
Yeah,
in.
don't get to come back. I know.
Right. Yeah. And I mean, all my support system was there. And I had like over probably 25 to 30 people that were there with me. The very next week, that policy changed, by the way, to only 3 people could come to the verdict if it was after 4:30.
Didn't know that.
So, and that I think still is the policy. Only 2, or it may have been dropped down to 2, but it's either 2 or 3 if the verdict comes after 4:30, because the courthouse closes at 4:30 and they don't staff security after that, even if there's a jury out. So the rest of the family waits out in the courtyard, and 2 or 3 people can go up and hear the verdict.
Was there just like one thing that you can think of in that trial that really made a difference with the jury? There were probably several things, but what do you think clinched it?
I think the fact that didn't actually testify, they just used the transcripts from his testimony in the first trial, because he actually was a really good witness and was able to garner sympathy from the jury, even though if the jury thought about it, the tale he was describing would put the bullet wounds on the other side of his body. That was one of the things that we had to point out to the prosecutors, because he said he was coming from the front of the car and he started shooting at him first, but his wounds were on the right side of his body, so the left side of his body would have been towards coming from the front of the car. But the state's witness testimony had him coming from the back of the car, and his wounds were on his right side of his body would be facing the car coming from the back of the car. So I think that him not taking the stand, even though they did point that out and made it a point to the jury to, you know, if he's coming from this way, his wounds would be over here. They did make it a point to point that out, but I think the fact that he didn't take the stand probably made all the difference.
Well, yeah, but you did your homework, and I think a lot of families are.
Well, and the PowerPoint that they used in closings, I mean, that honestly, I want to change my answer. Can I change my answer?
Of course.
The PowerPoint at the end was probably what locked it up, because that just guided them through step by step, and that's where they showed where the bullet wounds would be on if he was coming from this side and versus this side, and it just tied the bow on, you know, where did the drugs go, and just all the stuff that the first juror felt like was unanswered in the first trial.
Well, it worked. So,
and it's funny that you say that in the trial that I mentioned, the defendant in that case didn't take the stand in the first trial. He did take the stand in the second trial when he was convicted, and he didn't take the stand in the third trial. So you have the opposite situation. I think
it depends on how good of a witness they are. I mean, if they're charismatic and able to really garner sympathy with their story. I mean, he probably practiced it 100 times in his cell while he was waiting to go to trial.
He probably put on performances in the cell block, right?
Right.
Well,
hey, what if I say this?
You know, and you say that, and that's probably something that so often we don't know what the demeanor of a witness is going to be, in particular the defendant, because if he didn't give a statement and he can't be forced to testify, he has to choose whether he wants to testify. So we can prepare a cross-examination of him, but we don't always, we can't factor in the intangibles that you were talking about. Is he charismatic?
You can't give him a deposition either, right?
Right.
So you don't know what his story even is going to be until he takes the stand.
Exactly.
The defendant cannot be deposed?
Nope.
I did not know that.
That little Fifth Amendment.
Another fact that's come out in the probable cause.
The Fifth Amendment, you don't have to you can't be compelled to testify against yourself.
All right.
So,
part of our Constitution.
But the point on this, I think, also with a hung jury, the part that turns out sometimes to be good is you learn the strength and the weakness of your case. You may have a pretty good idea of where your weaknesses are, but until you've really put it in front of a jury and you really see how it's presented, if you think of a play, the prosecutor is frequently like the director of the play. Get the people in the right places, make sure they hit their cues, and get hunt. I mean, it's not that we feed them the lines other than tell them the truth, but you're not sure what the total of it will be till you actually see it. And we don't get dress rehearsals in this. So in the cases where we do get a hung jury, where it looks like we've got things that we can fix or emphasize more that seem to trouble the jury, and we can take those suggestions from family, from jurors, from our own evaluation of how the case played out. And sometimes we can give it a better performance, if you will, on a second trial.
I was just going to say, they're like performers.
Well, you know, every lawyer, unless they write out their closings or something, will go and sit back down, and as they're listening to the instructions being read, will kind of say, darn it, there was something I meant to say and I forgot to put it in. Particularly that final closing, because most folks have an outline or something. They know kind of what they want to say. They're responding to what the defense said in their closing. But it's just the nature of that's going to be a little more freewheeling than the first closing, where you can put it into a PowerPoint. You're controlling that, where you're responding in your rebuttal closing.
Right, so you have to work fast. It's like, I think the best preparation for this is for people to be on the speech team or the debate team.
Mm-hmm. A lot of lawyers, especially trial lawyers, did that in high school and mock trial teams in law school. Mm-hmm. It's great training. Anything that you have to think on your feet and come up with questions and then follow all the little unwritten rules we have, like don't ask a question on cross-examination to particularly a defendant that you don't know the answer to.
Or you can be like Joe Pesky and my cousin Vinny,
Yes.
and you can have a girlfriend who thinks up an answer and a rebuttal to everything you say. So anyway, if there's anything else you want to say, we are getting toward the end of our time. Any last thoughts on mistrials? Either one of you, Mike or my right hand?
Well, I think you showed kind of the trauma that goes through the family of a victim. And I would also throw out, think about if it's a sex crime, a rape case, or a child molest, where your primary witness generally is going to be the victim. And the emotional trauma that they go through to get ready for the trial. And then if it comes back that we believed them, but we just needed more, and it's very hard to comfort them and explain that, no, it's not that they didn't believe you, they believed you, but, well, then why isn't it guilty? And that is really hard for victims. And we probably get more hung juries for type of case on this kind of sex case, a rape or child molesting, where your primary evidence is coming from your victim.
I honestly think child molest is the worst thing you can be.
But it just puts that much more pressure. But I think the emotional roller coaster you went on shows how traumatic any trial can be, and how traumatic a homicide trial is for the family that's left behind.
Absolutely. All right, so I just wanted to say a little note about the song, The Probable Cause. Apparently it's become slightly controversial. It is my creation. I took about 4 probable causes. I mean, I've been writing these up for years now. One was I was in court. I did write one from the cop's point of view and then from my point of view. I recorded it with Big Keese, a local DJ with loud 103.3 FM. It's our hip hop station. He told me when we recorded that he knew somebody in every one of those situations. I wasn't trying to be controversial. I was just trying to be truthful, right? I have great respect for the criminal justice system, but I also, as I say in my verse, I see the flaws. We laid down the track. Big Keese added some sound. Then my husband came up with that percussion, which at first I thought was hilarious. Now I love it. So from now on, we're going to be leading with sort of an abridged version of that song, so you won't have to scroll through the whole thing if it does make you mad. But you will be able to access it on our website, theprobablecause.com. Will also probably be on our Facebook page, The Probable Cause. We're trying to put all our articles, all our podcasts on there. I do have 3 articles that have been posted on the website. We'll probably get them on the Facebook page. We will post our podcast there every single week that we record one, but there will also be interviews with newsmakers. I'm calling them newsmakers, people who make a difference. It could be any county in the 11 counties that we have here. I also want to say a little bit about misericordia, because it's almost become like a religious term, but it's a good Latin word, and it means mercy, and it means that we will be telling victim stories on there. So we'll have the newsmakers and misericordia, a little bit of Latin that we've thrown in there. If you have an idea for our podcast, please let us know through social media somehow. I've already had a couple people come and tell me, hey, I would really like to be on the podcast, and this is what I would like to discuss. So we will figure that out. And for now, we're going to sign off. I'm Jamie Duffy, your host, co-host Michael McAlexander, and my right hand. And it's goodbye for now from The Probable Cause. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.